Thank you, Your Honour. Before my learned friend opens the Crown case, I'm instructed to make an application pursuant to Section 590AA of the Criminal Code to exclude the interview that my client gave with police on the day he was arrested and charged with the offence. I will further be submitting to Your Honour that Your Honour ought to exercise Your Honour's discretion in excluding the interview on the basis that it would be unfair to my client in all of the circumstances to admit the interview into evidence. I turn now to the relevant sections of the Police Powers and Responsibilities Act which govern my application. Section 420 of the Act deals with the questioning of Aboriginal people, of which my client is clearly one. The Act states that unless a police officer is aware that a person has arranged for a lawyer to be present during questioning, the police officer must, as soon as reasonably practicable, notify or attempt to notify a representative of a legal aid organisation. I respectfully submit to Your Honour that by the officer having told my client he was going to be contacting ATSLs in relation to him being in custody, that the officer knew that my client was of Aboriginal descent. I would further submit, Your Honour, that notwithstanding the evidence of the officer that he did in fact contact ATSLs to inform them that my client was in custody, that telephone call was in fact never made. I say that on the basis that there is no additional evidence which in any way corroborates the evidence of the officer. And it would follow that Your Honour would ultimately find that the officer was not a credible witness and was unreliable, as demonstrated by the lack of evidence which backs up the claims made by the officer. I now turn to Section 420, subsection 3 of the Act, which provides for an officer to be able to not comply with Section 420, subsection 2, if he or she reasonably suspects that the person is not at a disadvantage in comparison with members of the Australian community. Your Honour, the case of the Crown and the Sailor, a 2012 Court of Appeal case. In this matter, a determination by a police officer that a Torres Strait Islander was not at a disadvantage was found to be reasonably based. The key difference between the case of Sailor and the matter before Your Honour today is that in the case of Sailor, the officer had in fact made independent inquiries with other persons in relation to that defendant. In the present matter, there has been no additional inquiries with anyone else, and the only inquiries made by the officer was with my client. Accordingly, this section cannot be said to have been activated, and it would follow that Your Honour would find that Section 420, subsection 2, subsection B of the Police Powers and Responsibilities Act was breached. I turn now to Section 420, subsection 4, subsection A of the Act. This Act stipulates that a police officer must not question a person unless before the questioning has started, the police officer has, if practicable, allowed the person to speak to the support person, which in this case is my client's mother, and if practicable, in circumstances in which the conversation will not be overheard. Notwithstanding that my client's mother was present during the questioning, my client was not afforded an opportunity to speak to my client in circumstances where it would have been extremely reasonable for police to do so. And further, he was not afforded the opportunity to speak to his mother in private and for advice to be given. And I would ultimately submit that Your Honour would find this section of the Act has also been breached. Finally, Your Honour, turning to Section 403. The Act is quite clear, and that it states that the maximum duration or the maximum time frame that one can be detained without charge is 8 hours. My client was detained for 9 hours and 5 minutes. This is a blatant breach of this section of the Act. Your Honour, turning to whether or not it would be unfair to admit the interview into evidence pursuant to Section 130 of the Evidence Act. If it is determined by Your Honour that the officers have breached the Police Powers and Responsibilities Act, there remains for the court to exercise its discretion in relation to excluding the evidence which resulted from the interview. Section 10 of the Act states that the Act does not affect the common law under which a court in a criminal proceeding may exclude evidence in the exercise of its discretion. If it was determined that the interview was not lawful, the court still needs to exercise its discretion in order to exclude the evidence. The relevant factors in relation to exercising that discretion are set out in the judgment of Bunning and Cross. The factors that stated there were whether or not there was a mistake by the police as distinct, deliberate, and disregard of the law, whether the illegality affected the cognizency of the evidence, the ease with which the law might have been complied with, the nature of the crime, and the intent of the legislator. Your Honour, notwithstanding any comments my learned friend might make about the probative value of the interview conducted on the day my client was arrested and charged, the conduct of the police officers in this case cannot merely be classified as an oversight. Their conduct was a blatant and willful disregard of the law. The officers could very easily have permitted my client a small amount of time to speak with his mother before being interviewed. The officer could very easily have telephoned Atzels to advise them that my client was in custody for the offence. This was all not done. And, Your Honour, I would respectfully submit that the disregard and willful disregard of the officer's responsibilities under the Act started from the moment my client was arrested to the moment he was charged with the offence. I accept that this crime is the most serious crime in the state. However, I do also note Section 7 of the Act, of the Police Powers and Responsibilities Act, which states that it is Parliament's intention that police officers comply with this Act in exercising powers and performing responsibilities under it. It would therefore follow that Your Honour would allow my application, unless I can be of any further assistance. Thank you.